genocide, or rare to people notice when fathers forced rape, daughters face this attention begs the question, why people that average child will break during times of peaceful, people drawn arbitrary plans allows designated for which violence is acceptable, effects are the same for everyone societal, and effects are dispersed more difficult to recognize, finish, to speak, for more so federal, some cuss, class citizenship, local time, state, federal, state, focus, and class, federal, between your bones and dogs, first face, abstract, opposition, by federal, state, tradition, to perceive that the country's not very change, traditional interpretation, public and private, all humans associate with private and all forms of domestic, legal, independent, civil society, state, forces, and challenges, the classic economy, sports circuit, overwhelming evidence comes from to be the bounces inherently private value, recognize the hybrid nature of foster creating the rugby Supreme Court, experience of stereotype, women's group, public ignorance, so they deny and the effect of rugby victims in abstract formalism, deny substantive equality, the sparse to domestic nonsense, group distinction, practice, equality, since most certainly reminiscent of Jim Crow, visuals fail, to protect, say, law, court, rights, and community, the skills, types, abstract formalism, Supreme Court, after summarizing the facts in 6 lifeless sentences, the most 6 pages, abstract, exposition of its project, for official proper protection, does not because function, force, and direct facility, the court said the Jim Crow era, we should be thankful that the majority of the location to rehabilitate drugs stop, the case comes to response to a private box is not a concern, that matches an abstract idealization of state power, if there were contest position 20 years more since, it would be a finalist and citizenship, is tied to political politics, figure 19 domestic policy, cannot separate the international policy, place out the demarcates rule of right and might, constantly internationalism, connected multi-security elements by the first lessons of state and international or regionally enforcing causes ecological destruction, figures of rugged dynamic relationship with interest informed by the LGBT reference to the constitution disruptive fledgling self-creation to the person gender and control, faithful for patient life, use pattern for precursors, crisis, gender identity, cultural issue, control, use of use rating from acid rain, global level completion, forming video, water, deforestation, certification, defects, extinction, marbles, and 96 biodiversity, fourth life sports, and people depends on because when we overexploit, we in our own survival and causes worse needs. I think this which will two masculine feminine word actually be targeted inside out 64 disorders and carving out and pursuit hustle and performance and professional goals from the sacred multitude to separate patriarchal was not rooted in anarchy, privilege, control, because value and control patriarchal societies that force the rise to be obsessed with revenge, structured by conscious opposition, resting on being representation of those nuclear to connect to foster peace, identity, plus and better, saying where nuclear work is spread good things happen, don't want for celebrate death, enemies, carrying to the about living in, to private elements, advantages, racism, Morrison upholds racist doctrine, regard to the 6 forms of reproduction, pictures, contemporary violence, misguided and confirmed racist church, for safety, comes multiple problems with the court of it, and the facts here, some court is the white mob, group of chickens, hundreds of defense convicted for a massacre, which hundred were murdered, separates cases, how to define self against those who done an entry based on legal consequence was that, as a form to state were not direct perpetrators of the court, which had blind eyed Morrison and Dr. helped shape racially vertical society, she described like dressed up as evil, unconstitutional tragic state action doctrines were found with racist, arbitrary categorized as confident identity active, not follow the promise of court, going below, be a losing battle, Supreme Court is over, Jim Crow in the past, it should do it again, and impact the psychic harm, element 3 people of color, with the case of present reality, God, the ethical flesh, and magic influence, love, to be as an 8 cities, some Chrome self-defined by the 2 racing bill, cause extinction, 2095, I doubt, is that clear because we travel in dialogue, I use the other person, not to pay, dehumanized hospital, proxy, serious country, very successful civilization, cause extermination, can, one measures the institutional office, and the present individual discrimination, maybe most stage forms of suppression, marginalization, marks people, non-sexual, honorable, as a people category, people of social life subjected to extermination, next advantage is the ADA, Morrison, section 5, precedent threatens it, this is expression, public, force, and create confidence in the section 5, testing, use, classification, 1, to maybe forces to get up and legal fast and type of cards, not for action. The question is how many laden with problems and turns the allocation are legacy for federal cards and like more some ADA is also only rational. It is review injustice demands the ADA social models and stability go right to 85 transformation with the less social product total disabilities, lack of complete change medical model, contrastable disabilities internal that deserves treatment, social change is required. Justice and the impact is genocide and war, although too because of the medical term studies done from the other that the general makes life healthy biological cause based on evolutionism enables war colonial genocide is a way of regenerating race masses become vital and biological next advantage is epistemology more than such legal sanctions in response to gender the law resting no two things for reflecting sexual life and natural division part people justice and politics create jurisdiction reflect and reinforce such assumptions pre-court decisions well decide how allocation affects understand the prompts of jurisdiction and gender and jurisdiction assess advancing quality comparative frame legislation is possible to compare race and other members must be on essential separation and gender assumptions using the same categories and these power committed to government and our studies are all misinformed through gender neutrality just give you some that 1970 topical about expensive things that rent that folks yeah the radical perspective contains such lead us to certain questions answers to practical tools what we look for depends on how we order experience as college students lens to shape our experience of the world they have concrete consequences and self-fulfilling prophecies ordering is a choice we move through reality rather than maps that function students and scholars are updated worldviews are inadequate disaster gender influences how we are how we live thinking clinton was 2 shapes identification of factors actions problems and alternatives 8 gender sensitive supports adequate and comprehensive understanding and unjust peace is worse than more patent 96 plus legal balance of sense breakdown private government life relations gender split and like Steve inside outside 1 million people die from war 19 million die from nuclear speaking doubts of organ out peace but justice peace becomes more than not more possible peaceful collectively in everyday lives of plaintiffs 16 rules 14 USC section 1 constitutional 14 10 a week clarify to solvency overrule confronts gender and Morrison vice bill 1 Morrison puts kind of says what ways to challenge all that paradigm 2 connection of solve problems constitutional collusion to benefit examination by courts, facts, and the direct consequences of rights are not adjudicated in values, not articulated, willingness of the courts and research legitimizing the responsibility of the courts that only transform legal culture with tended change in public values of breaks down impunity, making no three, definition, love, sex, and equality for gender, practical, economic, working, social, legal, activity, equality, same forth, without question, exists, regards off the custom between human body, sexual equality, and makes citizenship substantive, carcinogen, equals, it's not that form of children, and pleasant, and often that's often such that person should be considered for start, which is most that person making that for one remorse, and this is irrelevant, we can help just majority of the impact of legislation, very quickly, principles, leadership, or that is harm that changes our culture, both from the few race limitations, and invite transform the culture of fame and federal countries for being deeply powerful, teams for equality and discrimination. That was altering attitudes, behavior, practices, and also officials, and it empowers women. This goal for fundamental rights and section the system political problem and requires them political solutions that principally serve affirmation world value, serves self-collecting, giving sense of group, identity, and practice provides material relief. Wise men no one from the courts act as to improve real world life relief is real behaviors, limitation, misplaced competence, legal civil abuse recognized by national forms of violation entitled to compensation. She experiences vindication relief is not illusory symbolic, provides resources to make independent choices, criminal justice, disempowering, health, bank, through proceedings, circumstances, the jobs, criminal trials, blame, death, victim by synagogue, restaurants, benefit, people, for consequence, legal, side, pursuit, claim, adequate litigation, control, pedophilia, conference, at the end of police, complaints, and police, less circumstances, and the animals will be interpreted broadly, will harm, three judge, through reception, protection, convict, violence, lower court, conflict, sector, church, by budget, access, multiple victims, violence, force, limited, role, even more, and help the plaintiff, state, valid, protect, state, allegation, of self-sufficient support, the animus, this interpretation, critical, expansive language, favors and valid, and would create a per se rule, and challenge balance at the intersection, goal for no three factors, requirement of application, use, and questions, compensation, dispute, the ways of these topics, the claim of groups of women in the amount of cases is not relevant, takes no what application, the important not correcting discrimination, state is a different remedy than the federal government was trying to provide, but real effective encouraging states to do better job as impact of avoiding and deterring violence and formulation of equality, response to the imperative of justice through both West and Ohio. The point is not efficiency, utility, well-being, social welfare funds, just basic citizen equality, imperative, not just a good idea to justify state outcome, education, equality. Revision is a general paradigm shift to introduce critical thinking, guys, to imagine equal feature, articles, utility, equality, self-review, equality, change, revolutionary. This is not piecemeal, it's an audacious hope that just want equality, can give some trial a different way. That equality is resident, directing, subcode, equality, correcting the occasional exceptional police, and that defense of the rule of law in response to specific laws that tackle equality is a culturally relativist approach that condones millions to death and suffering daily. HRW no 6 women federal board of declaration of human rights competence is in Sierra Leone, Kosovo, Congo, Afghanistan, cooperate for women's weapon of war, men in Pakistan, South Africa, Peru, Russia, respects no people, men, boundary 12 records for Houston, people from Moldova, Nigeria, Republic of Burma, Thailand, Rwanda, Seoul, attracting from all South Africa and Mexico, women's ability to enter the workforce of Turkey, Morocco, Jordan, Kuwait, and Saudi Arabia face government sponsored discrimination. Abuses are relentless, systemic, widely tolerated. Our duty as activists to reject specific legal practices by which women are discriminated, excluded, segregated, raped, beaten, denied equal rights, killed, forced, assaulted, and sold. Arguments of cultural and appropriate rights or imperialism barely desensitize cultural relativism. A corrosive challenge to equality rights is a global struggle based on the rule of law. It requires us to defend solidarity, defend tradition, practice laws, to fight for freedom without apology or permission. The struggle must be about making women's life matter everywhere, all the time. This means taking action to stop discrimination and violence against women.
Okay, let's talk about your context. It cites overrun on the 14th Amendment. There are 5 sections of the 14th Amendment, 4 of which have nothing to do with, or nothing to do with the plan. I'm assuming, what section of the 14th Amendment do you overrule in? I mean,
we declare valid constitutional under the 14th Amendment in the plan.
In the plan, but like there are like 5 sections of the 14th
Amendment. Right, the holding in Morrison was that VAL is not an appropriate use of the Section 5 authority of Congress, so we hold it constitutional under the 14th Amendment.
Okay, now that was the citing under Ball. However, your resnick evidence, the citing the citizenship stuff is all about is not about Section 5. Section 5 is not about citizenship, correct?
Well, I think the more relevant part of your question is our resnick evidence, and that is not about the citizenship clause. It's about the jurisdictional lines that were gendered in Morrison, the federalism arguments that we're making about saying that violence against women is truly local and not truly national. That is essentialist, and
your resnick evidence concludes not only that we have to link the idea of gender to national citizenship. Yes.
Right, which is what the 14th Amendment guarantees.
No, because 14th Amendment Section 5 does not link it to it.
Okay, Section 1 says that everyone has equal citizenship, and Congress enforces Section 1 through Section 5.
Through Section 5.
That there's no
Yeah.
possible way to just rule on Section 1. That doesn't make sense.
Okay, then let's talk about your ADA evidence. This evidence indicates that we're going to test the viability of Section 5-based legislation. However, the American with Disabilities Act, if someone openly discriminates against a person with disabilities, they would have the ability to sue under such as the immunities and protection clause of the Constitution. It's not only reliant on the ADA, correct?
I honestly don't know. I don't know what that is, the immunities, whatever.
The immunities and protections is section 1 of the 14th Amendment, which indicates that no person shall be denied a discriminatory legislation.
I don't know, maybe
why wouldn't they be able to sue under that under your plan?
Well, our advantage is simply that the civil remedy in the ADA has been struck down and is further being challenged in lower courts because of the Morrison precedent. The civil remedy in the
Your
ADA
evidence
is...
indicates that it creates powerful incentives to test Section 5-based. Where does it indicate that they're actually testing it? This evidence is from 6 years ago.
It cites two decisions, here
Where?
at 1 and here at 2, in which there were complaints brought against enforcement of the ADA through civil remedy. Our point is that the civil remedy of the ADA is the only part of it that's social, not medical. It's important to recognize that disability is not something that needs to be treated, but rather as a result of lack of state protection, right? State discrimination. And so,
Yeah, but even then, individuals...
we're not saying that the entire ADA is our advantage. It's just the civil remedy part, the social part of it, has been targeted.
Where in your evidence, where in your evidence does it indicate that it's the civil remedy that's necessary to stop the medicalization of individuals?
The Eldon evidence does not speak to the link. It speaks to the impact.
I realize that. It says that by medicalizing the other, we can destroy them, right? But why is the civil remedy necessary for that?
That's the previous part.